Earlier today, the Supreme Court unanimously sided with a group of former college athletes in a dispute with the NCAA over rules limiting certain compensation. The High Court ruled NCAA limits on the education-related benefits colleges can offer athletes cannot be enforced. Here to share his thoughts on how this will affect college sports going forward is Santa Clara University professor Donald Polden. Professor, thanks for joining me. Talk to me about what this means for our current college athletes and ones that will be starting school here in the fall.
Today's decision by the Supreme Court was kind of expected after the oral argument in the case several months ago. In the oral argument, the justices across the ideological spectrum all had the unified position that the NCAA was unduly, improperly, illegally restricting the ability of student athletes to be compensated for their athletic performances in a very narrow area, and that is benefits unrelated to education. The decision is important for a couple of reasons. First of all, it was 9-0. The NCAA lost every one of the justices on the issue. Secondly, it applies to Division I and Division II football and basketball throughout the United States. And while the decision really focuses on the NCAA's limits or restrictions on benefits unrelated to education, those are things like limits on graduate education. Sometimes universities will provide for financial support for an athlete after he or she graduates and goes on and wants to continue to compete, but also earn a graduate degree. Loss of value insurance, clothing, allowances, travel expenses, etc. So it's kind of a narrow range, but the decision in the case was really quite expansive. And one of the justices, in writing a concurring opinion, said that this case, the analysis by the court really provided a blueprint for future litigation that would seek to restrict virtually all NCAA limits or restrictions on compensation earned by or awarded to student athletes.
How do you think this is going to affect recruiting for schools that might have more money to offer and more compensation to offer than others?
Well, this kind of opens a part of the floodgates here. And one interesting thing about the opinion of Justice Kavanaugh concurring was he pointed out that these restrictions in this kind of litigation is likely to continue until either there is a negotiated settlement between the athletes and the NCAA or legislation would be approved. And I assume he would mean federal legislation that would get into this area and trying to sort out appropriate compensation, appropriate areas of competition between schools in terms of what they could pay student athletes. So there, and I think that's right. I think that this opinion really sets out a blueprint for how the next case or a couple of cases in which student athletes will challenge the NCAA restrictions on undergraduate tuition scholarships, restrictions on student athletes' ability to be compensated for their name, image, and likeness, sponsorship, endorsements, and that sort of thing.
Well, you speaking about the name, image, and likeness, you know, a lot of these schools are making profit off of these students, whether that's with T-shirts that have their faces on them or jerseys with their names, that sort of thing. Talk to me a little bit about why this is just basketball and football that this applies to right now, and is there looking forward, are other sports going to be included in something like this?
I think it's unlikely it's going to get much beyond the big money sports. There could be a more global, more comprehensive legislation, for example, that would free up men's and women's student athletes across the board. But I think the near future is going to really focus on the money sports, which is Division I football and basketball. The Supreme Court decision today was just scathing in terms of its treatment of the NCAA. It referred consistently throughout the student athletes' right to compensation. Secondly, the Supreme Court again rejected the NCAA's position that, well, amateur athletics is something special. Consumers want to see amateur athletes and prefer that form of competitive football or basketball. The Supreme Court rejected that. They referred to this as a billion-dollar industry. They referred to the NCAA as a sprawling enterprise, and they also referred to it as the NCAA is operating a massive business, pointing out, for example, that March Madness NCAA basketball tournament is a $1.1 billion per year enterprise. So the opinion, much like the oral arguments, involved the justices, all of them saying that the NCAA business plan is flawed insofar as it's predicated or based on getting relatively uncompensated performances by student athletes. So that's definitely a look at the future, and the future does not look good for the NCAA.
In the past, I know athletes have been punished for an exchange of their signatures for goods and other services. Talk to me just a little bit about whether or not this vote affects situations like that.
This will not. This is there was an earlier case coming out of the San Francisco-based Court of Appeals, the Ninth Circuit Court of Appeals, that dealt with the name, image, and likeness of rights. Right to compensation for name, image, and likeness. And that was resolved against the student athletes. This opinion, however, it came from the U.S. Supreme Court, 9-0. It looked at a narrow branch of the compensation, the spectrum of compensation, and they said that there is a high barrier, high threshold that the NCAA has to it has to exceed in order for it to justify that kind of restriction. So I think that the next cases that we'll see again deal with name, image, and likeness, and also the NCAA's restriction on undergraduate student tuition scholarships. So there's more ahead here, unless, as Kavanaugh points out, there is some kind of settlement on a comprehensive scale in college athletics, or there is some legislation in the area. Right now, we've got 20-some states, I believe, that have state bills, including California, that seek to extend the right to compensation for name, image, and likeness to student athletes. There's some efforts by a couple of United States senators to get a federal bill in that area. So, in litigation, if the judge says, I think you all ought to go outside and talk about how to settle this, that's one of the strong messages that the Supreme Court gave to the NCAA in this case. This might be a good time, I think the court said, for the NCAA to look at how they can resolve this without future litigation.
So essentially, basically, these athletes, they obviously already receive scholarship funding. If certain athletes receive scholarship funding to be able to attend these schools, what other type of compensation would these athletes be able to reap from these schools?
Well, right now, as you point out, student athletes, the NCAA has the ability, and its member colleges have, and universities have the right to restrict the amount and degree and nature of tuition scholarships, they have a right to restrict their entitlement to compensation or benefits from outside the university or college for their name, image, and likeness. So that is kind of settled right now. That was outside of this case. This case went to several types of other kinds of compensation for student athletes. They held that the NCAA had failed to justify its restrictions on those. Now it's going back to the district court in Oakland, where the original case was tried, and I think some of the sorting out, if you will, of what colleges and universities in the future, what the leagues, conferences can do in the future, because there's a growing schism between the Power Five conferences, they call them. Those are the major football, basketball conferences in the United States. And then the rest of the teams, conferences, and leagues that are smaller, less prominent conferences. So they're going to go back and parlay, if you will, and figure out what this decision is going to mean for them in terms of how they can recruit students and the extent to which they can provide benefits or limit benefits in some of these non-educationally related areas.
Many layers to this, for sure.
And some complexity, but there's a couple of big decisions made in this, and I'm sure it's caught the attention of the NCAA, college universities, and their major arguments were rejected by the Supreme Court.
Professor Polden, thank you so much for joining me and kind of breaking down exactly what this vote meant today. Appreciate it.
Glad to do so. Thank you.
You're watching Chron On. We'll have more news after the break.